So this video is a summary of OCC licensing and application procedures. It's a condensed overview of the main points. This is not intended to be exhaustive or advice. This is for educational purposes only. This is my summary and synthesis of the relevant laws, regulations, and official guidance. This should not be considered a substitute for legal advice. Please consult with legal counsel for any questions you may have about how this applies to you. There are also links below to more detailed videos on various aspects of this topic. There are also links to key resources that include official guidance and commentary from the OCC. The main source is the Comptroller's Licensing Manual, CLM, which includes policies, procedures, and sample forms. There's also the website, which contains current forms, instructions, and contact information. The OCC strongly encourages pre-filing meetings. In particular, it recommends them for novel, complex, or unique proposals. So here's what you need to know. First, there are several critical definitions. Here are the key ones. First, an eligible bank or eligible savings association must meet all 5 of these criteria. 1. Well capitalized, as defined by 12 CFR 6.4b1. Has a strong CAMELS rating of 1 or 2. 3. Has a satisfactory CRA performance rating, if applicable. 4. Has a satisfactory consumer compliance rating of 1 or 2. And 5. Is not subject to any cease and desist orders, consent orders, or formal written agreements. Next, capital and surplus means for community banks. Capital and surplus means Tier 1 capital plus loan loss allowances. For all other institutions, it means Tier 1 and Tier 2 capital plus the remaining loan loss allowances. Next, well-managed means a composite rating of 1 or 2 under CAMELS or its foreign branch equivalent. ROCA, or a management rating of at least 2. If the management component is separately rated, a new institution is deemed to be well-managed if the OCC determines that the institution has satisfactory managerial resources. Next, licensing filing refers to any application or notice that a depository institution must file with the OCC for a corporate activity or transaction, including those submitted under the Bank Holding Company Act, the International Banking Act, or the Home Office, foreign branch, and agency, and for trust activities. And finally, eligible transaction is a licensing filing made by an eligible institution. Now those are the critical definitions. Let's look at the filing process. First, all filings must be certified under penalty of perjury, as containing no material misrepresentations. Each filing must also include the applicable fee, which is generally non-refundable. Filings may incorporate by reference materials from other agency filings, such as the form for registration and report of acquisition of control under the Bank Holding Company Act. Supporting documentation must also be submitted along with the filing. If the supporting documentation is not complete or sufficient, the OCC may consider the entire filing abandoned. The OCC has authority to conduct investigations, including background checks, to support its review of the licensing filing. Certain filings require fingerprints for individuals named in the filing. The OCC may examine and investigate all facts related to any licensing filing. Additionally, the OCC may assess additional fees to cover the cost of any additional work, including examinations or investigations. Once a licensing filing is received, the OCC will assign it a control number. That control number will then appear on all subsequent correspondence between the OCC and the filer regarding the licensing filing. The OCC's public process involves providing notice and an opportunity to comment. First, public notice of the filing must be published in a newspaper of general circulation in the community where the transaction is to be consummated. The notice must be published on the filing date or as soon as practicable thereafter. The notice must be in English and must also be published in another language if the demographics of the relevant community indicate a significant number of persons who speak that language. The public notice must contain the following information. 1. The date the filing was received by the OCC. 2. The name of the filing institution. 3. A brief description of the filing. 4. Procedures for submitting comments to the OCC. 5. The name and address of the OCC licensing office where comments should be sent. 6. the name and telephone number of the person or office to contact at the OCC, and 7. A reference to the weekly bulletin at www.uocc.gov. Within 30 days after the date of publication of the notice, the OCC will receive written comments regarding the proposed transaction. The OCC may grant an extension of the comment period if it finds that the information contained in the notice is not sufficient. For an interested person to effectively participate in the process, or for any other good cause shown, if the OCC believes that additional factual development is needed, it may modify or reopen the comment period or request additional information from interested persons. If the OCC receives adverse comments, it may seek further information or explanation from the filer or interested persons, or may schedule a meeting with them. If the comments are not adverse, the OCC will typically make a decision on the proposed transaction without a hearing. If the OCC determines that there are significant adverse comments or other reasons exist, such as a failure to provide required information, the OCC may decide to hold a hearing. During the comment period, any person may request a hearing in writing. The request must explain why written submissions are insufficient, to afford the person an adequate opportunity to demonstrate the views and to obtain a ruling on the issues. The OCC has discretion to grant or deny the request, or may grant the request in part. If a hearing is granted, the OCC will appoint a presiding officer to conduct the hearing in accordance with 12 CFR Part 19. Subpart B. All participants must file a notice of intent to participate within 10 days after the order granting the hearing is issued. In addition to public meetings that may be scheduled to address identified deficiencies in written submissions, private meetings may be held with filers to discuss issues that need clarification or resolution. These meetings may be conducted by telephone or in person, or, if deemed appropriate, as a formal meeting under 12 CFR Part 19, Subpart B. At the conclusion of the comment period, the OCC will evaluate the comments received, any additional information, and the results of any meetings held to determine whether to approve, conditionally approve, or deny the licensing filing. If the OCC approves the licensing filing, the decision will be issued in writing and will authorize the filer to engage in the activity or consummate the transaction. A conditional approval may impose conditions necessary to satisfy any supervisory, CRA, or consumer compliance concerns. If the OCC denies a licensing filing, it will issue a written decision explaining the reasons for the denial. A denial may be based on significant concerns identified during the review, including legal inconsistency with applicable laws and regulations, or a finding that the information provided is not sufficient for the OCC to make an informed decision. An institution may submit an appeal to the Deputy Comptroller for licensing or the Ombudsman if they believe the decision was issued in error or involves a matter of policy. The appeal must be filed in writing within 30 days after the decision is issued. If the appeal is from a decision by the Deputy Comptroller, the appeal may be to the Chief Counsel or the Ombudsman. If the filing was approved, a decision to nullify an approval may be made before or after the transaction is consummated. Nullification may be made if there has been a material misrepresentation in the licensing filing, violation of law or regulation, or an error of fact or law in the decision to approve the transaction. After a licensing filing is approved, the OCC may modify or suspend the approval if there is a material change in the circumstances since the approval was granted and before the transaction is consummated. Now let's look at the decision process. The OCC has the authority to approve or deny any licensing filing. An approval may be unconditional or conditional. Approval is typically based on the following factors. 1. Whether the proposed transaction is consistent with applicable law and regulation. 2. Whether the proposed transaction is consistent with the bank as safe and sound operation and compliance with laws and regulations. 3. Any impact on the bank's financial condition, including its capital adequacy. 4. Any impact on the competitive environment in the market area where the transaction is to be consummated. 5. Whether the proposed transaction would adversely affect the public trust in the OCC's supervised institutions. 6. The bank's history of compliance with consumer laws and regulations. 7. Whether the bank has an effective compliance program to ensure compliance with consumer laws and regulations. 8. Whether the bank has adequately addressed prior consumer compliance issues. 9. The bank's history of CRA performance, including any prior enforcement actions taken by the OCC in connection with the bank's CRA performance. 10. Whether the bank has adequately addressed prior CRA performance issues. In addition to these factors, the OCC will also consider any comments received during the public comment period. Now, let's look at the timeline and computations. First, the OCC will specify a time period, measured in days, that the filer may take to begin the approved activity or consummate the transaction. The OCC may extend the time period upon a showing of good cause. Typically, extensions are granted only when the delay is not within the control of the filer. The OCC will also specify a time frame, measured in days, within which the transaction must be consummated. If the transaction is not consummated within the specified time frame, the OCC may take appropriate enforcement action. If the OCC makes a modification or a suspension before the transaction is completed, the filer must promptly implement the modification or suspension. If the OCC determines that the decision was made in error, it may modify or nullify the original decision before or after the transaction is consummated. Now let's look at some key compliance points. Filings and other submissions to the OCC must include all required information and must be accurate and complete. Material misrepresentations in a licensing filing may subject the filer to enforcement action and potential criminal penalties under 18 U.S.C. Section 1001. Time is of the essence in complying with timelines set by the OCC. If a response is due to the OCC on a particular date, the response must be received by the OCC by the end of the business day on that date. If the last day of the prescribed period falls on a weekend or a federal holiday, the response must be received by the end of the business day on the next business day. Unless otherwise specified by the OCC, time computations in the licensing process are not inclusive of the day on which the triggering event occurs. For example, if the OCC issues a request for information on a Tuesday, the response would be due on the 15th day following that Tuesday. If the 15th day falls on a weekend or a federal holiday, the response would be due on the next business day. Keep in mind that the OCC generally processes filings as complete as of the day the OCC receives all required documents and payments. Finally, let's look at some strategic considerations. First, early engagement with the OCC through a pre-filing meeting may help avoid problems later in the process. Second, maintaining the status of an eligible institution can be very beneficial because it provides for an expedited review of certain transactions and eliminates the public notice and comment period for other transactions. Third, effective public notice and comment management is essential for approval. Fourth, interested parties should factor in the cost of filing fees.